If you live in Texas, Mississippi, or Louisiana, the Supreme Court just made it super hard for you to mass protest there. Hi, I'm Casey. I'm a former government teacher, and I make political content using humor to cope in these dark, dark times. And y'all, it is bleak. And for once, not because the Supreme Court said something or did anything. This is because the Supreme Court didn't elect to hear a case. Record scratch, what? Let me explain. If there is a case involving whether or not something is constitutional, it's heard in the federal courts. And we begin our journey here at the U.S. District Court, typically. And then whoever lost oftentimes will appeal it to a circuit court of appeals. More on that in a second. Then the loser tries to appeal to the Supreme Court. Many cases are sent to the Supreme Court, but the Supreme Court only elects to hear a few because there's only 9 justices and they don't have that much time. They gotta go spend their time on their yachts or whatever else Harlan Crow and Leonard Leo and the billionaires of the far right have bought them. But I digress. The highest court to hear the case and rule on the case makes it law. In this case, Doe versus McKesson, it was heard in the Fifth Circuit Court of Appeals. The Fifth Circuit, where law goes to die, encompasses Texas, Louisiana, and Mississippi, and has a real iffy relationship with the Constitution, specifically when it involves your rights to do things. Unless it's religion. They really like religion there. So because the Supreme Court decided not to hear the case, Doe versus McKesson, the ruling from the Fifth Circuit Court stood and was law. In June of last year, the Fifth Circuit Court of Appeals ruled that an organizer of a mass protest could be held liable for any type of violence or injury that happened at the protest. In this case, it involved Decay McKesson, a protest organizer involved in the Black Lives Matter movement, who organized a very large protest in 2016 in Baton Rouge, Louisiana. Unfortunately, during this protest, an unnamed police officer was struck in the head and injured. And even though McKesson, the person that he's suing, the organizer of the protest, was not involved in the violence whatsoever, and evidence shows that, he is being held liable by the Fifth Circuit Court. And just for visual reference, this is what they look like. Now, that's going to make it almost impossible to organize larger protests in these cities because the protest organizers can be held liable for anything that happens at that protest, even if they weren't involved in it. Probably asking yourself, Casey, isn't there a constitutional right to assemble? There is, in fact, and it's in the very First Amendment in our Bill of Rights, the right of people to peaceably assemble. And then you might say, but Casey, there was not peace at this assembly. And I would say, sure, that's true. But McKesson, right, the organizer of the protest event, wasn't involved in the violence. So he was peaceably assembling. So why didn't the Supreme Court intervene? In their opinion, they've already settled this matter in many cases involving speech, specifically political speech. In this case of NAACP versus Claiborne Hardware Co., the Supreme Court held that protest organizers could not be held liable for the violence of protesters unless they incited the violence knowingly and purposefully. What were the things that McKesson, the protest organizer, did that made an exception to the NAACP versus Claiborne Hardware Co. case? So the Fifth Circuit said that because McKesson organized the protest in front of a police station and obstructed access to the building, that was a problem. That in and of itself was enough for him to realize that violence or some sort of injury could take place, that he didn't dissuade protesters who allegedly stole water bottles from a grocery store, and then for taking them onto a public highway, which is violation of Louisiana criminal law. Which, yeah, okay, but again, the spirit of this law that was created by the Supreme Court, the spirit was to enable political protest. And by holding protest organizers liable for any type of violence that takes place during a protest, you're effectively eliminating the capacity for anyone to hold any type of political demonstration or protest in Texas, Mississippi, and Louisiana, which again is at odds with the entirety of the civil rights movement in this country. And it is no surprise that the Fifth Circuit Court of Appeals, of all courts, would rule this way.